भारतीय नागरिक सुरक्षा संहिता 2023। भारतीय नागरिक सुरक्षा संहिता 2 Section 185 Power to order cases to be tried in different sessions divisions. What is Section 185 about? Section 185 gives the High Court the power to decide which Sessions Court will try a case when there is confusion or conflict about jurisdiction between different sessions divisions. Main provision of Section 185. When it is uncertain which sessions division should try a case, or a case may be tried in more than one sessions division under the law, the High Court may decide which sessions court shall try the case and pass any order necessary to ensure a proper and fair trial. Simple meaning: sometimes a criminal case involves multiple districts or sessions divisions, or can legally be tried in more than one place. In such situations, the High Court acts as the final authority to choose the correct sessions court. This avoids confusion, delay, or conflicting decisions. Example: an offense is committed partly in Sessions Division A and partly in Sessions Division B. Both divisions are legally competent to try the case. To avoid dispute, the matter is placed before the High Court. Under Section 185, the High Court orders that the case will be tried in one specific sessions court. Purpose of Section 185: resolves jurisdictional conflicts, ensures orderly administration of justice, prevents parallel or competing trials, strengthens supervisory role of the High Court. भारतीय नागरिक सुरक्षा संहिता 2023। Section 186 Power of High Court to decide district where inquiry or trial shall take place. What is Section 186 about? Section 186 empowers the High Court to decide which district court will conduct the inquiry or trial when there is confusion or conflict of jurisdiction between courts of different districts. Main provisions of Section 186. A conflict of jurisdiction: when two or more courts of different districts have taken cognizance of the same offense, or there is doubt about which district court should conduct the inquiry or trial. Though High Court's authority, the High Court may decide which district shall have jurisdiction and direct that the inquiry or trial be held in that district. 3. Binding decision: the High Court's decision is final and binding on the subordinate courts concerned. Simple meaning: sometimes more than one district court claims authority over the same criminal case. To avoid conflicting proceedings, delay, or harassment of parties, the High Court steps in and chooses one district where the case will continue. Example: a cybercrime affects victims in District A and District B. Courts in both districts start proceedings. Under Section 186, the High Court decides that only District A will conduct the trial. Purpose of Section 186: prevents parallel or duplicate trials, ensures certainty and judicial discipline, protects accused and victims from unnecessary litigation. Bharatiya Nagarik Suraksha Sanhita 2023. Section 187, power to issue summons or warrant for offence committed beyond local jurisdiction. What is Section 187 about? Section 187 empowers a magistrate to take action even when an offence has been committed outside his local jurisdiction. It ensures that offenders are not protected by distance or jurisdictional limits. Main provisions of Section 187. 1. Key cap issue of summons or warrant. If a magistrate has reason to believe that a person within his jurisdiction has committed an offence outside his local limits, the magistrate may issue a summons or warrant against that person, though forwarding to competent court. After the person is produced or appears, the magistrate shall send the person to the magistrate having jurisdiction over the place where the offence was actually committed. 3. Temporary custody. The magistrate may order temporary custody or require a bond for appearance until the person is forwarded to the proper court. Simple meaning: even if a crime is committed in another district, a magistrate can still act if the accused is found within his area. The magistrate helps in securing the accused and sending him to the right court for trial. This avoids delay and prevents accused persons from escaping arrest by moving locations. Example: a person commits fraud in City A. He is found living in City B. The magistrate in City B issues a warrant under Section 187, produces the accused, and sends him to the magistrate in City A for trial. Purpose of Section 187: prevents offenders from evading justice by changing places, enables cooperation between courts, ensures smooth and speedy criminal process. Bharatiya Nagarik Suraksha Sanhita 2023. Section 188, offence committed outside India. What is Section 188 about? Section 188 deals with offences committed outside India by Indian citizens or on Indian registered ships or aircraft. It explains when and how Indian courts can try such offences. Main provisions of Section 188. Ek who is covered. An offence may be dealt with in India if it is committed by a citizen of India, outside India, or by any person on a ship registered in India or an aircraft registered in India. Though trial in India, such offence may be inquired into and tried as if it were committed in India. 3 prior sanction required. However, no such inquiry or trial can begin without the prior sanction of the central government. Simple meaning: if an Indian citizen commits a crime abroad, or a crime happens on an Indian ship or aircraft, then Indian courts can try the case, but only after permission, sanction from the central government. This balances India's criminal jurisdiction and international law and sovereignty of other countries. Examples: an Indian citizen commits fraud in a foreign country may be tried in India after central government sanction. A crime occurs on an Indian registered ship in international waters. Indian courts have jurisdiction. An offence happens on an Indian aircraft flying abroad, triable in India with sanction. Purpose of Section 188 extends Indian criminal jurisdiction beyond borders, prevents offenders from escaping justice by going abroad, ensures compliance with international legal norms. Bharatiya Nagarik Suraksha Sanhita 2023. Section 189, Receipt of evidence relating to offences committed outside India. What is Section 189 about? Section 189 explains how Indian courts may collect and receive evidence when an offence has been committed outside India. It provides a legal mechanism for cross-border evidence gathering. Main provisions of Section 189. Ek evidence from outside India. When an offence is committed outside India, covered under Section 188. Evidence required for inquiry or trial may be collected from a foreign country. Though mode of taking evidence. Evidence may be obtained through commissions or by other lawful means permitted under international arrangements. 3. Admissibility. Such evidence is treated as valid evidence in Indian courts, provided it is collected according to prescribed legal procedure. Simple meaning: if a crime involves acts done abroad or witnesses or documents located in another country, then Indian courts are not helpless. They can legally obtain and use foreign evidence for the case. This is essential for cybercrimes, financial frauds, international offences. Example: an Indian citizen commits online fraud while living abroad. Key bank records and witnesses are in a foreign country. Under Section 189, Indian authorities can lawfully obtain that evidence and use it during trial in India. Purpose of Section 189: facilitates international cooperation in criminal justice, ensures fair trials in cross-border crimes, prevents offenders from escaping due to lack of evidence. Bharatiya Nagarik Suraksha Sanhita 2023. Section 190 Cognizance of Offences by Magistrates. What is Section 190 about? Section 190 explains how and when a magistrate can take cognizance of an offence. Taking cognizance means the magistrate applies his judicial mind to the offence and decides to proceed according to law. Main ways a magistrate may take cognizance. A magistrate of the first class and certain second-class magistrates may take cognizance of an offence. एक on a police report. When the police submit a charge sheet or final report under Section 173. Though on a complaint. When a private complaint is made by any person, victim or otherwise. 3 key cap on information or own knowledge. Upon information received from any person other than police or the magistrate's own knowledge that an offence has been committed. In such cases, the magistrate must have legal authority to try the offence. Simple meaning: a criminal case formally begins in court only when the magistrate takes notice of the offence and decides that legal action should start. This can happen through police action or directly through a citizen's complaint. Examples: police file a charge sheet for cheating, magistrate takes cognizance under Section 190. 1A. A person files a complaint of defamation, magistrate takes cognizance under Section 190. 1B. Magistrate personally witnesses an offence may take cognizance under Section 190. 1C. Purpose of Section 190 marks the starting point of judicial proceedings. Ensures court control over criminal prosecution. Allows access to justice even without police initiation. Bharatiya Nagarik Suraksha Sanhita 2023. Section 191 Transfer of case when magistrate takes cognizance. What is Section 191 about? Section 191 protects the right of the accused when a magistrate takes cognizance of an offence on his own knowledge or on information received, and not on a police report or complaint. Main provision of Section 191. When a magistrate takes cognizance of an offence on information received from any person or on his own knowledge, the accused has a right to object. If the accused so objects, the magistrate shall transfer the case to another competent magistrate or the appropriate court as provided by law. Simple meaning: if a magistrate personally knows about an offence or receives informal information and takes cognizance, then the accused can say, "I do not want this magistrate to try my case." In that situation, the law ensures fairness and impartiality by transferring the case. Example: a magistrate personally witnesses a minor offence in his area. He takes cognizance under Section 190. The accused objects to being tried by the same magistrate. Under Section 191, the case is transferred to another competent magistrate. Purpose of Section 191 ensures neutral and unbiased trial, protects the accused from possible prejudice, strengthens confidence in judicial fairness. Bharatiya Nagarik Suraksha Sanhita 2023. Section 192 Making over of cases by magistrates. What is Section 192 about? Section 192 empowers a Chief Judicial Magistrate (CJM) or a magistrate of the first class to transfer, make over, cases to other competent magistrates. This helps in efficient case management and proper distribution of judicial work. Main provisions of Section 192. One key cap power of Chief Judicial Magistrate. The CJM may make over any case to any magistrate subordinate to him, who is competent to try or inquire into the case. To key cap power of magistrate of the first class. A magistrate of the first class may make over a case to another magistrate only if authorized by the Chief Judicial Magistrate. Teen scope. The transfer can be made after cognizance is taken and at any suitable stage as per law. Simple meaning: higher magistrates can assign or reassign cases to other magistrates to reduce workload, to ensure speedy trials, to place cases before the most appropriate court. This is an administrative and judicial convenience provision. Example: a CJM has many pending cases. He transfers some cases to other competent magistrates under Section 192. Those magistrates then handle the cases as if they were originally filed before them. Purpose of Section 192 ensures smooth functioning of magistrate courts, prevents backlog and delay, allows flexible and efficient administration of justice. Bharatiya Nagarik Suraksha Sanhita 2023. Section 193 Cognizance of offences by courts of session. What is Section 193 about? Section 193 states that a court of session cannot take cognizance of an offence directly. It can do so only after the case has been committed to it by magistrate unless the law expressly provides otherwise. Main provision of Section 193. No court of session shall take cognizance of any offence unless the case has been committed to it by magistrate under the law. Exception: if any other law specifically allows the Sessions Court to take direct cognizance, that provision will apply. Simple meaning: serious criminal cases triable by a Sessions Court must first pass through a magistrate. The magistrate takes initial cognizance and then commits the case to the Sessions Court for trial. The Sessions Court cannot start proceedings on its own in ordinary cases. Example: police file a charge sheet for murder, a Sessions tribal offence. The magistrate takes cognizance, completes preliminary formalities, and commits the case to the Sessions Court. Only then can the Sessions Court begin the trial. Purpose of Section 193 maintains proper judicial hierarchy, ensures magistrate-level scrutiny before serious trials, prevents bypassing of preliminary judicial safeguards. Bharatiya Nagarik Suraksha Sanhita 2023 Section 194 Additional and Assistant Sessions Judges to try cases made over to them. What is Section 194 about? Section 194 explains how cases before a Sessions Court are distributed among the Sessions Judge, Additional Sessions Judges, and Assistant Sessions Judges. It ensures proper allocation of work within the Sessions Division. Main provisions of Section 194. एक power of Sessions Judge. The Sessions Judge may make over, assign any case to an additional Sessions Judge or Assistant Sessions Judge for trial or disposal. To key-cap authority of Additional Sessions Judge. An Additional Sessions Judge can try cases made over to him by the Sessions Judge. Has the same powers as the Sessions Judge for such cases. 3 key-cap authority of Assistant Sessions Judge. An Assistant Sessions Judge can try cases made over to him, but only those cases which he is legally competent to try, generally less serious Sessions cases. Simple meaning: in a Sessions Court, one judge does not handle all cases alone. The Sessions Judge distributes cases among other Sessions Judges. This helps speed up trials, reduce backlog, and ensure cases are heard by competent judges. Example: a Sessions Judge has many pending cases. He assigns a serious murder trial to an additional Sessions Judge and a comparatively less serious case to an Assistant Sessions Judge. Each judge conducts the trial as per law. Purpose of Section 194 ensures efficient functioning of Sessions Courts, provides flexibility in handling heavy caseloads, maintains judicial order and hierarchy. Bharatiya Nagarik Suraksha Sanhita 2023 Section 195 Prosecution for contempt of lawful authority of public servants for offences against public justice and for offences relating to documents given in evidence. What is Section 195 about? Section 195 places restrictions on who can start criminal proceedings for certain sensitive offences. For these offences, courts cannot take cognizance unless a specific complaint is made by the concerned public authority or court. Main restrictions under Section 195. A court cannot take cognizance of the following offences unless there is a written complaint by the proper authority. 1 key-cap offences against lawful authority of public servants. Examples include offences like disobedience to lawful orders of a public servant, obstruction of public servants in discharge of duties. Complaint must be made by the public servant concerned or another public servant to whom he is administratively subordinate. Though offences against public justice. These include offences such as giving false evidence, perjury, fabricating false evidence, false statements in judicial proceedings. Complaint must be made by the court in which the offence was committed or a court to which that court is subordinate. 3 key cap offences relating to documents used in court. These include forgery of documents, using forged documents, when such documents are produced or given in evidence in court. Complaint must be made by the court concerned, not by a private individual. Simple meaning: for certain offences that affect public authority or interfere with judicial proceedings. Private individuals cannot directly file criminal cases. Only the concerned public servant or the court itself can authorize prosecution. This prevents misuse of criminal law, harassment through false or retaliatory cases. Examples: a person disobeys a magistrate's lawful order prosecution only if the magistrate or superior authority files a complaint. A witness gives false evidence in court case can start only if the court files a complaint. A forged document is produced during trial, only the court can initiate prosecution. Purpose of Section 195 protects judicial proceedings from abuse, maintains authority of courts and public servants, prevents frivolous or vindictive prosecutions. Bharatiya Nagarik Suraksha Sanhita 2023. Section 196 Prosecution for offences against the state and certain other offences. What is Section 196 about? Section 196 requires prior sanction before a court can take cognizance of certain serious offences, mainly those affecting the security of the state, public order, or relations with foreign states. Main provisions of Section 196. एक prior sanction is mandatory. A court cannot take cognizance of specified offences without prior sanction of the central government or the state government as applicable. Though types of offences covered. These generally include offences related to waging war or attempting to wage war against the government, sedition-like acts endangering sovereignty and integrity, promoting enmity between groups, acts prejudicial to national security or public tranquility. 3. Who grants sanction? Depending on the nature of the offence. Central government, national security, foreign relations, or state government, public order within the state. Simple meaning: for offences that can affect national security, disturb public peace, or impact state authority. The law requires government approval first before a criminal case can start in court. This ensures serious laws are not misused and prosecution is initiated only after careful scrutiny. Examples: a case alleging acts against the sovereignty of India court needs prior central government sanction. A case involving promotion of enmity between communities, state government sanction is required before trial begins. Purpose of Section 196 protects against frivolous or politically motivated prosecutions, ensures responsible use of serious criminal laws, balances national security with individual rights. Bharatiya Nagarik Suraksha Sanhita 2023 Section 197 Prosecution of Judges and Public Servants. What is Section 197 about? Section 197 protects judges and certain public servants from criminal prosecution for acts done while performing official duties unless prior sanction is obtained from the appropriate government. Main provisions of Section 197. Ek who is protected. Judges and public servants who are not removable from office without government sanction. Though acts covered. The protection applies when the alleged offence was committed while acting or purporting to act in the discharge of official duty. 3 prior sanction required. A court cannot take cognizance of such offence without prior sanction of the central government or the state government, depending on who controls the public servant service. 4 purpose of sanction. Sanction acts as a filter to ensure honest officers are not harassed for bona fide actions, while still allowing prosecution where wrongdoing is apparent. Simple meaning: if a judge or senior public servant is accused of an offence connected with official work, a criminal case cannot start straight away. First, the competent government must examine the facts and grant permission, sanction for prosecution. Examples: a government officer is accused of illegal action while enforcing a lawful order. Court needs government sanction before taking the case. A judge passes a judicial order alleged to be wrongful. Prosecution requires prior sanction. Note: if the act has no reasonable connection with official duty, e.g., bribery, personal assault, courts may hold that Section 197 protection does not apply. Purpose of Section 197: protects honest officials from vexatious litigation, ensures fearless and independent decision-making, maintains balance between accountability and administrative efficiency. Bharatiya Nagarik Suraksha Sanhita 2023 Section 198 Prosecution for offences against marriage. What is Section 198 about? Section 198 restricts who can initiate criminal proceedings for offences relating to marriage. For these personal and sensitive offences, courts cannot take cognizance unless a complaint is made by the aggrieved person or someone legally permitted. Main provisions of Section 198. One key cap complaint by aggrieved person only. For offences against marriage, such as adultery, cruelty, etc., as defined in substantive law. The court can take cognizance only on a complaint by the person aggrieved. To key cap who can complain when the aggrieved person cannot. If the aggrieved person is a minor or a woman who is unable to make a complaint due to physical or mental incapacity. A complaint may be made by a close relative or another person with the permission of the court. 3 key cap special rule for adultery type offences. In cases relating to adultery where applicable under law, the husband of the woman is treated as the aggrieved person. If the husband is absent or incapable, another person may complain with court permission. Simple meaning: offences connected with marriage are private in nature. So, strangers or outsiders cannot start criminal cases for such offences. Only the person whose marital rights are affected can approach the court. This prevents misuse of criminal law and unnecessary interference in personal relationships. Examples: a wife alleges cruelty by her husband, she herself must file the complaint. A minor girl is affected by marriage-related offense, her guardian may file the complaint with court approval. A third party cannot file a case just because they know about the marital dispute. Purpose of Section 198 respects privacy of marital relationships, prevents frivolous or motivated prosecutions, ensures only genuinely affected persons invoke criminal law. Bharatiya Nagarik Suraksha Sanhita 2023. Section 199 Prosecution for defamation. What is Section 199 about? Section 199 lays down special rules about who can start a criminal case for defamation and how such cases are to be filed. Because defamation affects personal reputation, the law limits prosecution to the person defamed with certain exceptions. Main provisions of Section 199. A complaint by person defamed. A court can take cognizance of defamation only on a complaint made by the person whose reputation is harmed. Police cannot start defamation cases on their own by FIR. To key cap when the aggrieved person cannot complain. If the person defamed is a minor or of unsound mind or otherwise unable to make a complaint. A complaint may be made by a close relative or another person with the permission of the court. 3. Defamation of public servants. If defamation is alleged against the President, Vice President, Governor, Minister, or other public servants in respect of their official conduct, the public prosecutor may file the complaint with prior sanction of the government. Such cases are tried by Court of Session. Char safeguard. Even in public servant cases, the court must ensure the prosecution is not frivolous or politically motivated. Simple meaning: defamation cases are personal, not general crimes. So, only the person whose reputation is damaged can normally go to court. In special cases, public servants, the state may prosecute, but only with strict safeguards. Examples: a person spreads false statements harming your reputation, you must file the complaint yourself. A newspaper allegedly defames a minister regarding official work case may be filed by the public prosecutor with government sanction. A third party cannot file a defamation case just because they read the defamatory statement. Purpose of Section 199 protects freedom of expression from misuse of criminal law. Ensures only genuinely affected persons prosecute defamation. Prevents harassment through proxy complaints. Bharatiya Nagarik Suraksha Sanhita 2023. Section 200 Examination of complainant. What is Section 200 about? Section 200 explains what a magistrate must do after taking cognizance of an offence on a private complaint. It requires the magistrate to examine the complainant and witnesses on oath to see whether there is a prima facie case. Main provisions of Section 200. एक examination on oath. When a complaint is filed, not a police case. The magistrate shall examine the complainant on oath. Any witnesses present may also be examined on oath. Though recording of statements. The statements made during examination must be reduced to writing and signed by the complainant, the witnesses, and the magistrate. 3 exception, public servant complaint. If the complaint is made by a public servant acting in official capacity or a court, the magistrate may dispense with examination under this section. Simple meaning: when a private person files a criminal complaint, the magistrate does not issue summons immediately. First, he questions the complainant under oath and checks whether the complaint appears genuine and lawful. This step helps filter false or frivolous cases. Example: a person files a private complaint of cheating. The magistrate examines the complainant on oath, records his statement, and examines any supporting witnesses. Only if satisfied, the magistrate proceeds further, summons, inquiry, etc. Purpose of Section 200. Prevents misuse of criminal courts. Ensures judicial scrutiny at the very beginning. Protects innocent persons from baseless complaints. Bharatiya Nagarik Suraksha Sanhita 2023. Section 201 Procedure by magistrate not competent to take cognizance. What is Section 201 about? Section 201 explains what a magistrate must do when a complaint is filed before him, but he is not competent, has no jurisdiction to take cognizance of the offence. Main provisions of Section 201. One key cap if the complaint is in writing. The magistrate shall return the complaint to the complainant with an endorsement indicating the proper court where it should be filed. To key cap if the complaint is not in writing, oral complaint. The magistrate shall direct the complainant to approach the proper magistrate having jurisdiction. 3. No decision on merits. The magistrate does not examine the truth or falsity of the complaint, only decides jurisdiction competence. Simple meaning: if you file a complaint in the wrong court, the magistrate will not dismiss it outright. Instead, he will return it or guide you to the correct court. This protects complainants from losing their case due to a technical mistake. Example: a person files a complaint of a serious offense before a magistrate who has no power to try or take cognizance of that offense. Under Section 201, the magistrate returns the complaint, endorsing that it should be filed before a competent magistrate or sessions court. Purpose of Section 201: ensures cases are heard by the correct court, prevents dismissal on mere technical grounds, promotes fairness and access to justice. Bharatiya Nagarik Suraksha Sanhita 2023. Section 202: postponement of issue of process. What is Section 202 about? Section 202 allows a magistrate to postpone issuing summons or warrants against the accused and to first make a limited inquiry or order an investigation. This is done to decide whether there is sufficient ground to proceed. Main provisions of Section 202: एक postponement of process. After examining the complainant under Section 200, the magistrate may postpone issuing process, summons warrant, though inquiry or investigation. The magistrate may conduct an inquiry himself or direct a police officer or another person to investigate. Sole purpose: to find out whether there is enough ground to proceed. 3. Key cap mandatory inquiry when accused lives outside jurisdiction. If the accused resides outside the magistrate's territorial jurisdiction, an inquiry or investigation must be conducted before issuing process. This is a mandatory safeguard. 4. Key cap no police investigation in certain cases. If the offence is triable exclusively by the Court of Session, the magistrate cannot direct police investigation under this section. He may conduct inquiry himself. 5. Limited scope. This inquiry is preliminary, not a full trial, focused only on whether the case should move forward. Simple meaning: before calling an accused to court, the magistrate can double-check the complaint. This protects people from being summoned on false or weak complaints. Especially important when the accused lives far away or the complaint seems doubtful. Example: A person files a private complaint against someone living in another state. The magistrate does not issue summons immediately. Orders a preliminary inquiry under Section 202. Only if satisfied, the magistrate issues summons. Purpose of Section 202: prevents harassment through frivolous complaints, protects accused persons from unnecessary summons, ensures careful judicial scrutiny before proceeding. Bharatiya Nagarik Suraksha Sanhita 2023. Section 203 Dismissal of Complaint. What is Section 203 about? Section 203 empowers a magistrate to dismiss a private complaint if, after examining the complainant and considering the inquiry or investigation, if any, he finds no sufficient ground to proceed. Main provisions of Section 203. 8 grounds for dismissal. After examination under Section 200 and inquiry investigation under Section 202 if conducted. If the magistrate believes there is no sufficient ground to proceed, though recording reasons, the magistrate must record brief reasons for dismissing the complaint. This ensures transparency and accountability. 3 effect of dismissal. The complaint is dismissed at the threshold without issuing summons to the accused. Simple meaning: if a complaint appears false, baseless, or legally weak, then the court can stop the case at an early stage without troubling the accused. This saves time of the court and unnecessary hardship to innocent persons. Example: a complainant files a cheating case with no documents or witnesses. After examining the complainant and inquiry, the magistrate finds the story unreliable. Under Section 203, the complaint is dismissed with reasons. Purpose of Section 203: filters out frivolous or malicious complaints, protects accused from needless prosecution, ensures judicial efficiency. Bharatiya Nagarik Suraksha Sanhita 2023. Section 204 Issue of process. What is Section 204 about? Section 204 explains when and how a magistrate issues process, summons or warrant against the accused after being satisfied that there is sufficient ground to proceed. Main provisions of Section 204. 1. When process is issued. After considering the complaint, Section 200, and inquiry or investigation, Section 202, if any. If the magistrate is satisfied that there is sufficient ground to proceed, he shall issue process against the accused. Though type of process. Summons usually issued for less serious offences. Warrant may be issued for serious offences or where law permits. 3. Supply of complaint copy. In complaint cases, a copy of the complaint must be supplied to the accused along with the summons or warrant. 4. Fees and process. The magistrate may require payment of process fees by the complainant. If fees are not paid within the fixed time, the complaint may be dismissed. Simple meaning: once the magistrate decides this case deserves to go forward, he formally calls the accused to court by issuing a summons or a warrant. This marks the official beginning of proceedings against the accused. Example: a magistrate finds prima facie evidence of cheating in a private complaint. He issues summons under Section 204 to the accused. The accused must now appear before the court and face the case. Purpose of Section 204: transitions a case from preliminary scrutiny to active prosecution. Ensures accused is called to court only after judicial satisfaction. Balances complainant's rights with protection against frivolous cases. Bharatiya Nagarik Suraksha Sanhita 2023. Section 205. Magistrate may dispense with personal attendance of accused. What is Section 205 about? Section 205 allows a magistrate to exempt the accused from appearing personally in court and permit appearance through a lawyer either at the start of the case or at any later stage. Main provisions of Section 205. एक dispensation of personal attendance. The magistrate may dispense with the personal attendance of the accused and permit him to appear through a pleader, lawyer. To key cap stage at which exemption can be granted. This power can be exercised at the time of issuing summons or at any subsequent stage of the proceedings. 3. Court's discretion. The exemption is not automatic. The magistrate considers nature of the offense, conduct of the accused, possibility of delay or misuse. 4. Key cap power to require appearance later. Even if exemption is granted, the magistrate may direct the accused to appear personally at any later stage if necessary. Simple meaning: the law recognizes that personal appearance in court may sometimes be unnecessary or burdensome. So, in suitable cases, the accused can be represented by a lawyer and avoid repeated court appearances. But the court keeps full control and can call the accused anytime. Example: an accused lives in another city and the offense is minor. The magistrate allows exemption under Section 205. Permits appearance through a lawyer. Later, if required, e.g., for identification, the magistrate may order personal appearance. Purpose of Section 205. reduces unnecessary hardship to accused persons, saves court time, ensures flexibility without compromising justice. भारतीय नागरिक सुरक्षा संहिता 2023 Section 206 Special Summons in Cases of Petty Offences. What is Section 206 about? Section 206 provides a simplified procedure for dealing with petty offences. Instead of requiring the accused to appear in court, the magistrate may allow the matter to be settled by pleading guilty through post or electronic means and paying a fine. Main provisions of Section 206. 1. Applicability. Applies to petty offences that are punishable only with fine or punishable with imprisonment up to 6 months or punishable with both where the magistrate considers it appropriate. 2. Special summons. The magistrate may issue a special summons stating the offence and specifying the amount of fine. 3. Key cap option to plead guilty without appearing. The accused may plead guilty in writing or through electronic means and send the specified fine by post or approved mode. 4. No personal appearance required. If the accused follows this procedure, personal attendance in court is not required. 5. Court's discretion. The magistrate may still require personal appearance if necessary. Simple meaning: for minor offences, the law avoids unnecessary court appearances. So, the accused can accept guilt, pay the fine, and close the case quickly without coming to court. This saves time, money, and judicial effort. Example: a person is charged with a minor municipal or traffic-related offence. The magistrate issues a special summons with a fine of 500 rupees. The accused pleads guilty in writing, pays the fine by post electronic mode. The case ends without court appearance. Purpose of Section 206: speedy disposal of petty cases, reduces court congestion, minimizes inconvenience to citizens. भारतीय नागरिक सुरक्षा संहिता 2023 Section 207 Supply of copies of police report and other documents to the accused. What is Section 207 about? Section 207 ensures that the accused gets copies of all important documents relied upon by the prosecution in cases instituted on a police report charge sheet. It is a key safeguard for a fair trial. Main provisions of Section 207. 1. Documents to be supplied. The magistrate shall, without delay, furnish the accused with copies of the police report, charge sheet under Section 173, the first information report, FIR, statements of witnesses recorded by police under Section 161, confessions and statements recorded under Section 164. Any other relevant document relied upon by the prosecution. Though free of cost. All these copies must be supplied free of cost to the accused. 3 exception for voluminous documents. If a document is very bulky, the magistrate may allow the accused to inspect it instead of giving a physical copy. Simple meaning. Before the trial starts, the accused must know the full case against him. He must receive FIR, witness statements, and other evidence documents. This allows the accused to prepare his defense properly and avoid surprise or unfair disadvantage at trial. Example: police file a charge sheet for cheating. Before framing charges, the magistrate supplies the accused with FIR copy, witness statements, documents relied upon by police. Only after this, the case proceeds further. Purpose of Section 207 upholds the right to a fair trial, ensures transparency in prosecution, enables effective legal defense. Bharatiya Nagarik Suraksha Sanhita 2023. Section 208 Supply of copies of statements and documents to accused in other cases. What is Section 208 about? Section 208 applies to cases instituted otherwise than on a police report, i.e., private complaint cases, which are triable by the Court of Session. It ensures that even in such cases, the accused receives copies of essential documents before the case is committed to the Sessions Court. Main provisions of Section 208. 1. When it applies, the case is based on a private complaint, not a police charge sheet, and triable exclusively by the Court of Session. Though documents to be supplied, the magistrate shall furnish the accused, free of cost, with copies of statements recorded under Section 200, Examination of Complainant, statements recorded under Section 202, Inquiry Investigation, any other documents produced by the prosecution complainant and relied upon. 3. Before committal. These copies must be supplied before the case is committed to the Sessions Court. Simple meaning. In serious cases started by private complaints, the accused must not be kept in the dark before sending the case to the Sessions Court. The magistrate gives the accused all important statements and documents. This puts the accused on equal footing with police report cases. Example: a private complaint alleges a serious offence triable by Sessions Court. After preliminary inquiry, the magistrate decides to commit the case. Before doing so, under Section 208, copies of statements and documents are supplied to the accused. Purpose of Section 208 ensures fair trial rights in complaint-based sessions cases, prevents surprise and prejudice to the accused, Maintains parity with Section 207 Police Report Cases. भारतीय नागरिक सुरक्षा संहिता 2023. Section 209 Commitment of Case to Court of Session. What is Section 209 about? Section 209 explains the procedure a magistrate must follow when a case is triable exclusively by the Court of Session. Once preliminary requirements are met, the magistrate must send the case to the Sessions Court. Main provisions of Section 209. When it appears to the magistrate that the offence is exclusively triable by the Court of Session, the magistrate shall: 1. Key cap commit the case to the Court of Session. The magistrate does not conduct the trial himself, though supply required documents. Ensure that the accused has been supplied copies under Section 207 Police Report Cases or supplied copies under Section 208 Complaint Cases. 3. Remand or bail. The magistrate may remand the accused to custody or grant bail as per law until the Sessions Court takes over. 4. Forward records. Send to the Sessions Court the case records, documents, and any relevant material. 5. Notify public prosecutor. Inform the public prosecutor so that the case can be properly presented before the Sessions Court. Simple meaning: for serious offences like murder, rape, dacoity, etc., the magistrate acts as a gateway court. He checks whether documents are supplied and whether the case belongs to the Sessions Court. Then he formally transfers the case for trial. Example: police file a charge sheet for murder. The magistrate supplies copies to the accused, grants or refuses bail, and commits the case to the Sessions Court under Section 209. The Sessions Court then begins the trial. Purpose of Section 209: maintains proper division of judicial work, ensures sessions trials start with all formalities complete, protects accuseds' procedural rights before serious trials. भारतीय नागरिक सुरक्षा संहिता 2023. Section 210 Procedure to be followed when there is a complaint case and police investigation in respect of the same offence. What is Section 210 about? Section 210 deals with situations where a private complaint case is pending before a magistrate and a police investigation is also going on for the same offence. It lays down how the magistrate should act to avoid parallel proceedings and conflicting decisions. Main provisions of Section 210. एक stay of complaint proceedings. If the magistrate finds that a police investigation is in progress for the same offence, he shall stay, pause the complaint proceedings and call for a report from the police. To keycap if police file a charge sheet. When the police submit a report under Section 173. If it relates to the same accused and offence, The magistrate shall try both cases together as if they were instituted on a police report. 3 key cap if police do not file a charge sheet. If the police report states that no offense is made out or the accused is not sent for trial, then the magistrate shall proceed with a complaint case. Simple meaning: if two cases, complaint plus police case, exist for the same incident, the court will not run both separately. Priority is given to the police investigation. Final action depends on what the police report says. This avoids double trials, conflicting judgments, and harassment of the accused. Example: a person files a private complaint of assault. Later, police register an FIR and investigate the same assault. The magistrate pauses the complaint case, waits for the police report. If police file a charge sheet, both matters are merged and tried together. If police close the case, the private complaint continues. Purpose of Section 210 prevents parallel proceedings, ensures consistency in criminal justice, protects accused from double jeopardy-like situations. Bharatiya Nagarik Suraksha Sanhita 2023. Section 211 Contents of Charge. What is Section 211 about? Section 211 explains what a charge must contain when a court formally accuses a person of an offense. It ensures the accused clearly understands the exact accusation so that he can prepare a proper defense. Main provisions of Section 211. A clear description of offense. Every charge must state the specific offense the accused is charged with. Though reference to law. If the offense is defined under a particular law, the name of the law and the section number must be mentioned in the charge. 3 essential particulars. The charge should contain time and place of the offense as far as possible and the person or thing against whom or in respect of which the offense was committed. 4 Presumption of legal knowledge. The law assumes that mentioning the offense and legal section is sufficient notice to the accused of what the charge means. Simple meaning: a charge is like a formal written accusation. It must be clear, specific, and legally precise, so the accused knows what exactly he is accused of and under which law. No vague or confusing charges are allowed. Example: instead of saying, "You committed cheating," the charge should say, "You committed the offense of cheating punishable under section of the relevant law on date at place." Purpose of Section 211. Ensures fair notice to the accused. prevents surprise or ambiguity at trial, upholds the right to a fair defense. Bharatiya Nagarik Suraksha Sanhita 2023 Section to 12 Particulars as to time, place and person. What is Section 212 about? Section to 12 explains the additional details that must be included in a charge so the accused clearly knows when, where, and against whom the alleged offence was committed. Main provisions of Section 212. एक time and place. The charge must state the time of the alleged offence and the place where it was committed as clearly as possible. Though person or property involved. The charge must also specify the person against whom the offence was committed or the property or thing involved. 3 key cap when exact details are not known. If precise time or place is not known. The charge is still valid if it gives reasonable indication sufficient to inform the accused of the matter. Simple meaning. A charge should answer these basic questions for the accused. When did the alleged offence happen? Where did it happen? Against whom or what was it committed? This prevents confusion and helps the accused prepare a proper defense. Example. Instead of a vague charge like, "You committed theft," a proper charge would say, "You committed theft on or about 10th March 2025 at Delhi of a mobile phone belonging to X." Purpose of Section 212. Gives clarity and certainty to criminal charges. Protects the accused from vague accusations. Ensures fairness and transparency in trials. Bharatiya Nagarik Suraksha Sanhita 2023 Section 213 When manner of committing offence must be stated. What is Section 213 about? Section 213 requires the charge to explain how the offence was committed when the nature of the case makes it necessary. It adds details about the manner or method of the offence to avoid ambiguity. Main provision of Section 213. If the nature of the case is such that merely stating the offence, time, and place is not sufficient, then the charge must also state the manner in which the offence was committed. This applies especially when the offence can be committed in different ways and the accused needs clarity to prepare an effective defense. Simple meaning. Sometimes, just saying what offence happened is not enough. In such cases, the charge must also explain how exactly the offence was carried out. This ensures the accused is not left guessing about the allegation. Examples. Cheating. The charge should explain how the deception was practiced, false promise, forged document, etc. Criminal breach of trust. The charge should state how the entrusted property was misused. Forgery. The charge should specify what document was forged and in what manner. Purpose of Section 213. removes vagueness from criminal charges, gives the accused full and clear notice of allegations, strengthens the right to a fair trial. Bharatiya Nagarik Suraksha Sanhita 2023. Section 214. Words used in charge to be construed in ordinary sense. What is Section 214 about? Section 214 says that the words used in a charge must be understood in their ordinary, everyday meaning, unless the law gives them a special definition. Main provision of Section 214. The words and expressions used in a charge shall be interpreted in their ordinary sense, except where a specific law assigns a special legal meaning to those words. Simple meaning. A charge should be simple and understandable, not filled with confusing or technical language. The accused should be able to understand what the allegation means in plain language, without needing complex legal interpretation. If a word has a special legal meaning, then that legal meaning will apply. Examples. If the charge says theft, it will be understood in the ordinary sense, unless the law defines theft in a special way, as it does in substantive criminal law. If a legal term like entrustment is used, it will carry the legal meaning given by law, not a casual meaning. Purpose of Section 214. Makes charges clear and intelligible. Prevents misunderstanding or ambiguity. Helps the accused clearly grasp the accusation. Bharatiya Nagarik Suraksha Sanhita 2023. Section 215. Effect of errors. What is Section 215 about? Section 215 explains that small mistakes or omissions in a charge do not automatically invalidate the trial. An error matters only if it has actually misled the accused or caused a failure of justice. Main provision of Section 215. Any error, omission, or irregularity in the charge, such as wrong section number, slight mistake in description, minor omission of details, shall not be treated as material unless the accused was misled and such error has occasioned a failure of justice. Simple meaning. Not every mistake in a charge is serious. If the accused clearly understood the accusation and was able to defend himself properly, then minor defects in the charge will not cancel the case. But if the mistake confused or prejudiced the accused, the court can treat it as serious. Example. The charge mentions a wrong section number but clearly describes the offense. The accused understands the allegation and defends himself. Under Section 215, the trial is not invalid. However, if the charge is so vague or incorrect that the accused does not know what he is being tried for, it may amount to a failure of justice. Purpose of Section 215. Prevents cases from failing on technicalities. focuses on real justice, not clerical mistakes. Balances fairness to the accused with effective prosecution. भारतीय नागरिक सुरक्षा संहिता 2023 Section to 16 Court may alter or add to any charge. What is Section 216 about? Section to 16 gives the court the power to alter, change, or add to a charge at any time before judgment is delivered. This ensures that the charge correctly reflects the offence disclosed by the evidence. Main provisions of Section 216. 1 key cap power to alter or add. The court may alter an existing charge or add a new charge at any time before judgment. To key cap reading and explaining the new charge. Every alteration or addition must be read and explained to the accused. 3. Protection against prejudice. If the alteration addition is likely to prejudice the accused or the prosecution, the court may adjourn the trial or grant time to prepare a defense. Char recall of witnesses. The court may recall or re-examine witnesses already examined to ensure fairness after the change in charge. Simple meaning. Sometimes, during trial, new facts emerge or the original charge turns out to be incorrect or incomplete. Section 216 allows the court to correct the charge without restarting the entire trial, while still protecting the accused's right to a fair defense. Example: an accused is charged with simple hurt. During trial, evidence shows grievous hurt. The court alters the charge under Section 216, explains the new charge to the accused, gives him time to adjust his defense if needed. Purpose of Section 216: ensures charges match the true nature of the offence, prevents offenders from escaping due to technical mistakes, maintains fairness by giving the accused full opportunity to defend. भारतीय नागरिक सुरक्षा संहिता 2023 Section 217 Recall of witnesses when charge is altered. What is Section 217 about? Section 217 protects the rights of the accused and the prosecution when a charge is altered or added under Section 216. It allows both sides to recall, re-examine, or further examine witnesses to meet the changed charge. Main provisions of Section 217. एक right to recall witnesses. When a charge is altered or a new charge is added, the prosecution and the accused may recall any witness already examined and examine such witness with reference to the altered or added charge. Though court's discretion. The court may refuse recall only if it considers that the request is made for the purpose of delay or it is not necessary in the interest of justice. 3. Fair opportunity. This section ensures that Neither side is taken by surprise, and both sides get a fair chance to deal with the new charge. Simple meaning: if the court changes the charge during trial, the accused and prosecution must be allowed to re-question witnesses or bring out facts relevant to the new charge. This avoids injustice caused by sudden changes in the case. Example: an accused is originally charged with simple hurt. The court later alters the charge to grievous hurt. Under Section 217, the accused can recall the doctor or eyewitnesses to challenge evidence relevant to the new, most serious charge. Purpose of Section 217: ensures fair trial after alteration of charges, prevents prejudice to accused or prosecution, maintains balance between procedural flexibility and justice. Bharatiya Nagarik Suraksha Sanhita 2023. Section 218, separate charges for distinct offences. What is Section 218 about? Section 218 lays down the general rule that for every distinct offence, there must be a separate charge and a separate trial. This rule protects the accused from confusion and prejudice. Main provision of Section 218: one key cap, one offence, one charge, one trial. For each distinct offence committed by a person, there shall be a separate charge, and each charge shall be tried separately. Though exceptions exist, this is the general rule, but Sections 219 to 223 provide exceptions, where multiple offences or accused persons may be tried together. Simple meaning: normally, if a person commits different offences, he should not be tried for all of them in one single case. Each offence gets its own charge and its own trial. So the accused clearly understands each accusation and is not unfairly prejudiced by facing many charges at once. Example: a person commits theft on one day and assault on another day, unrelated incidents. Under Section 218, there should be one trial for theft and a separate trial for assault, unless the case falls under an exception in later sections. Purpose of Section 218: prevents confusion and prejudice, ensures clarity and fairness in criminal trials, protects the accused's right to a proper defense. Bharatiya Nagarik Suraksha Sanhita 2023. Section 219, 3 offences of the same kind within 1 year. What is Section 219 about? Section 219 is an exception to the general rule in Section 218. It allows multiple offences of the same kind to be charged and tried together under certain conditions. Main provisions of Section 219: एक same kind of offence. The offences must be of the same kind and punishable under the same legal provision or with the same punishment. Though time limit, the offences must have been committed within a period of 12 months, 1 year. Teen maximum number. The accused may be charged with and tried at one trial for not more than 3 such offences. Simple meaning: if a person commits up to 3 similar offences within 1 year, then the court may combine them into one trial instead of holding separate trials. This saves time while still protecting fairness. Examples: a person commits 3 thefts within 1 year, all 3 thefts can be tried together. A person commits 4 thefts in 1 year, only 3 can be tried together. The 4th must be tried separately. A person commits theft and cheating cannot be combined under Section 219 because they are not offences of the same kind. Purpose of Section 219: avoids unnecessary multiple trials, saves judicial time and resources, balances efficiency with the accused's